In this video, I am going to be talking about your right to a speedy trial or a speedy preliminary hearing in a criminal case. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be talking about your right to have a speedy trial or a speedy preliminary hearing in a criminal case and whether or not you should waive it. Now, you might hear that, and if you don't know what I'm talking about, you're like, waive my right? Why would I do that? I know I'm not going to, waive my right against self-incrimination. I know I'm not going to waive my right and let the cops search my car, search my house. Why would I waive my right to a speedy trial or speedy preliminary hearing? Good question. Now, this video is part of a series of videos, and it does stand alone by itself if you're only interested in this topic, but this is part of a series of videos on a criminal case timeline, which you can download down below. It's a PDF. And this is something that I gave to my clients, that I created for my clients. It's not marketing material or anything. It's something that I gave to them to explain, hey, here's an overview of this whole process. Of course, I am here to explain it to them, but when I started giving this to them, I wasn't sure if it was going to help or not. I started seeing that the people who read this had a much better understanding of what to expect overall. And I think that that's really valuable. In a criminal case, you have to make decisions, right? You have to decide, am I going to take this offer? Am I not going to? Am I going to push on? Am I not going to? Your attorney will advise you, but you may not. How are you supposed to know, okay, if I say no to this, what's going to happen next? When does my side come out? Does it ever come out? What? So anyway, this is to hopefully shed some light on that. Okay, so all defendants who are accused of, felonies have a right to have a preliminary hearing and then a trial within a certain time period. For misdemeanors, it's a right to have a trial. Now, what is important here is that what I've seen is that at almost every court date, especially when you have the public defender, they don't have time to really explain everything to you. I see the defendants are waiving their right to a speedy trial or speedy preliminary hearing for 30 days, 60 days, without really knowing why or without it benefiting them. And I always tell my clients, okay, if you are out of custody, if you are not in jail, and we need to wait and we think it might benefit you, we need to wait for example, an expert, a psych evaluation, whatever it is, something that will marginally benefit you or maybe majorly benefit you, or maybe some additional evidence, additional discovery, something like that we want to have time to make sure we do our own review of, not get it at the last second before trial. Yeah, okay, I'm probably going to suggest that maybe you do waive your time. We're not rushing to trial. We want to make sure we're as prepared as possible. But if you are in jail, then you should not, and nobody should ask you to, including your attorney, you should not waive your right to a speedy preliminary hearing or a speedy trial unless it benefits you. So if you've been to court in California for a criminal case, you have probably heard you have a right to have a speedy trial within X amount of days, depending on COVID, depending on whether it's a preliminary hearing or a trial, depending on time you waived previously of your arraignment. Do you waive and give up that right and agree that we can come back on X day at this time? Now, this is something the judge generally is asking the defendant, and the defendant's like, what am I supposed to say? I see this all this time, this look of waive time. And sometimes you'll see the defendants who say no, I don't want to waive any time because nobody explained to them why, and there may not be a good reason. It may be their attorney's schedule, or it may be the judge's schedule. Many times it is. So I always tell my clients, unless it is going to benefit you, if you are in custody, we should be moving the case forward. And yes, I may suggest that you waive some of your time, but we should keep it on a short leash if you are in jail, right? Especially if we don't think that the state is going to be able to prove their case at trial. Why would we let this thing extend out and drag on so much? So I explain here, every single time we have a client who is in custody, we have time. You need to understand what the purpose is, the potential benefit, and then you should have the option, waive time or not. And it's not if you say, it shouldn't be if you say, no, I'm not going to waive any time, then I'm like, all right, well, I'm done with you. And I see that attitude quite a bit. It should be like, okay, well, here's what we can do within that time. You know, if it's that some piece of discovery, some piece of evidence is outstanding from the district attorney, then I'm going to say, Your Honor, my client doesn't have to waive time. They have the right to have a speedy trial. The DA is going to have to just go and get that piece of evidence from the police or not use it whatsoever. If it's an expert that we have, I mean, the best I can do if it's court appointed is ask for them to go ahead of other clients, depending on if it will not negatively affect those other clients, like if they're out of custody and they're okay with that. So that is, that's what I can do and do all that I can. I personally, in terms of getting ready for trial, I wouldn't ask my client, hey, can you waive your time and just sit in jail for an extra 60 days while I get ready for trial? Or even 30 days, or, if it was the next day, I might. But I have a good system. I can get ready for trial very quickly if I need to. And most attorneys who are pretty experienced in trial should be able to do that too. You should be aware that if you have an attorney asking you to waive 30 days or 60 days so that they can get ready for trial, they're not spending 30 days or 60 days getting ready for trial. It's essentially because of their own schedule. Now, if you're out of custody, like if I have a vacation and somebody's out of custody, I might expect them to waive that time. But if they're in jail, no. Anyway, I hope that this was helpful. I thought that this was really, even though this isn't part of like a timeline exactly, it is about time. This is something that's so important that so many people don't understand, and it's never explained to them in these criminal cases. So I hope that you found this helpful. You can find the criminal case timeline download down below. If you do have a question, feel free to leave it in the comment section. I do read them all, sometimes to my detriment. And if you have a criminal case in California that you want a consultation on, you can find a link to consult with me down below. You can also find my number right there.